What is a trust? A trust is a relationship created at the direction of an individual, the settlor, in which one or more persons, the trustees, hold property subject to certain duties to use and protect for the benefit of others, the beneficiaries. Trust law was developed in England and has been in use for centuries. There are many different types of trusts that are used in different situations. A common example of a trust would be where a will provides money for a child. The will may appoint a trustee to hold and invest the money until the child reaches a certain age. A trust may also be used to achieve a goal over a considerable period of time. For example, a settlor may establish a trust to fund a scholarship or charity for the long term from the income on the trust property. Alberta's Trustee Act is based on 19th century English law. It has seen some changes over the years, but has never been comprehensively reviewed and has fallen out of step with modern practices and issues. In 2012, the Uniform Law Conference of Canada published the Uniform Trustee Act, a modern trust statute suitable for enactment across Canada. We undertook a project to see if the Uniform Act was suitable for Alberta. Our work was guided by several principles and values. Trustee legislation should be modern and reflect good trust practice. It should be clear, easy to understand, and plainly describe a trustee's duties and powers with very little need for court interpretation. It should be easy for settlers, trustees, and beneficiaries to understand what they need to do. Trustee legislation should establish trustee powers, which are necessary for proper administration of trusts in situations where powers are not adequately enabled by the trust instrument. And trustee legislation should describe court authority to direct trustees and otherwise intervene if necessary to ensure trusts function properly. We're recommending that Alberta adopt the Uniform Trustee Act with some modifications to reflect Alberta's trust law and practice. Key changes in new trustee legislation would include allowing a broader range of evidence to understand the settlor's intent if the trust document is not clear, a clearer process to apply to the court to approve a variation to a trust that is not provided in the trust document, greater flexibility for trustees to administer the trust without having to seek court approval in specific situations. Where there are multiple trustees, allowing decisions to be made by majority rather than requiring unanimous decisions. This will allow trust decisions to be made and prevents one trustee from holding veto power. And clearer guidance on what amounts to a conflict of interest for a trustee and guidance on how to act when a conflict arises. See our full report at www.alri.ualberta.ca and follow us on Twitter and LinkedIn for the latest in Alberta law reform.